Hi, hello everybody. I'm Nancy Hoffman. I'm here to talk a little bit about my experience as an arbitrator. I think it's important that you understand what my background is in order for my remarks to make sense. Um, I have a long career as an advocate, both on behalf of labor and unions and employees, as well as on behalf of management. I am an Iowa School graduate, by the way. And I think that this background that I have of many years, I won't say how many, is really informed my arbitration practice, and it impacts my view of in two separate ways. One is I think it's really important that when an arbitrator comes into a dispute, that he or she has some understanding of the business model um, within which the case that is before him or her arises. Most of my time has been as an advocate has been in the public sector, although I have private sector experience as well. And having a sense of how things work or are supposed to work has been invaluable for me as an arbitrator. My practice has been in the context of labor relations. I'm not a one-shot arbitrator where I walk into a dispute, help the parties resolve it, and then never see them again. I see the same advocates on both sides over and over again, and I fundamentally understand that the relationship continues. It began before I got there. It has to make it through the day that we're spending together, and it continues long after I've left. So I think that's an important distinction to understand if you're considering becoming a neutral, to consider in what context, if there is a specific context. Um, when I say labor relations, the parties that appear before me are representatives of the employer, and then generally speaking, representatives of the union in that employment relationship. The other thing that's important about that is this thing that I just mentioned about it being an ongoing relationship. So the parties have to live together after this decision and after the next decision and the next decision. And it's not a one-off like it is in court or in some other situations. And that also means that the role of the arbitrator, in my opinion, is a little different. It's a little more nuanced than if one is coming in solely for the purpose of settling or issuing a decision in one dispute. The contract, as you probably know, sets forth the terms under which I got there. They set forth my jurisdiction to a large extent, and they also can, many do, they restrict my award in some form or other as to what it is that I can and can't do. Common language being that I can't change the contract, but in some cases when you talk about disciplinaries, which I'll talk about in a second, I may be limited by what kind of discipline I can impose if I find indeed that discipline is necessary. So moving into actual arbitrations, you probably know that in this context that I'm talking about, there are two different types of arbitrations. Generally, there are those that result from disciplinary issues, and there are those that result from disputes under contract language. And each of these areas have their own jurisprudence that's been developed over many years, particularly here in New York State, which was one of the earliest states to have collective bargaining, at least in the public sector. And they have, besides jurisprudence, they have certain rules of the road, how it is that arbitrators are supposed to function in that context. I want to spend a few minutes talking about disciplinary cases, and then I'm going to give you an example of a case that I recently struggled with respect to what to do. A good number of disciplinary cases, particularly nowadays, I think it's reflective of a lot of the things that we're finding out ourselves in life. They result from things that don't happen at the workplace, but happen outside the workplace. We're not seeing a lot of horseplay cases or things along those lines that are confined to behavior and activity at the worksite, but situations that arise with people's health, with people's family members, etc. But the impact of those things is what shows up at the workplace. And it's in that context that the individual becomes the subject of discipline. A lot of cases have revolved around, at some point or other, health issues. Health issues, everything from disease and treatment and things along those lines, whether it's of an individual or of a family member. And sometimes it pulls in things like rehab and being out of work for a long period of time to deal with health issues, and how that impacts the employment place all becomes a part of a disciplinary issue. So just to give a little specificity to that, an employee misses a lot of work or is late a lot of times getting to work, and that behavior exceeds whatever it is that the employer has by way of a policy or an expectation, generally written, but sometimes not so, or a specific directive that has been issued to that particular employee, such as anytime you're absent and does not have prior approval, you must get medical documentation. And most of us know that getting medical documentation from the doctor is not the easiest thing in the world. And then there's questions of, is this an adequate or acceptable documentation? And then doctors have forms and they check the box, excuse from such and such a date. Some of the forms say work or school. They're used in both contexts, but excuse from such and such a date may return with or without restrictions, and it's electronically signed. That may or may not become the issue in arbitration because it may or may not be acceptable by the employer. But at the end of the day, there are things that I, as an arbitrator, must be sure that I know, and this informs how I conduct my hearing. But I must know certain things by the end of the day, and hopefully the parties have, their representatives have made that easy for me by presenting it through their testimony and through their documentation. I must know why the individual has been missing work or late. I must understand the circumstances that drive the behavior. I must know what's happened previously. Is this the first time that conduct has manifested itself, or is this the third or fourth or fifth time that the individual has been disciplined for the same kind of conduct, excessively late or excessive absences or undocumented absences being conduct? What has the employer done to try to address this previously? And I'm not just talking about counseling memos or early steps of discipline, but have they tried, depending again on what the issue is, to adjust shifts? Have they tried to deal in some other way by making references to employee assistance programs, or advising the employee who's having this difficulty about their other entitlements, family medical leave, or American with disabilities, or reasonable accommodation, those kinds of things? What's the employer done? The employer is not helpless here and is not innocent in many of these situations. And I must also, as the arbitrator, I must also know what's happened since the discipline was issued, because a major element of an appropriate award or an appropriate disciplinary penalty, shall we say, is whether or not it's going to stick the landing. Is this going to help the employee to get to work or to not have to leave work early, or whatever the issue is that underlies the discipline? So the best estimate of that is, has the employee's behavior changed in any way since they were served with this notice of discipline? Cases don't stop with a notice of discipline and then get heard a week later. It's usually months later, certainly weeks later, and more often than that, months later. Also underlying the inquiry here for the arbitrator is this a situation where discipline is intended to be punitive, to actually punish the individual? And a good example of that would be if it involved theft, or if it involved insubordination, refusal to follow an order. Those are higher levels of disciplinary problems, and they usually don't allow for the alternative to punitive discipline, which is progressive discipline, where you're imposing some kind of a penalty, a small fine or something along those lines, a loss of accruals, because what you're really looking to do is change behavior. You're not looking to penalize the person, but to change behavior. And then something that I'm most interested in, and I generally find some way to be sure that the parties have representatives have addressed this is what is the employee planning on doing going forward in order to improve their conduct in respect to whatever it is that is the cause of the discipline. So here's my most current example of all this, and I call this, I don't know if you guys are familiar with 5-alarm chili, but when I used to live in Manhattan, I used to send away to someplace in Texas, and you'd get your chili powder and all the things to make good chili, and you could pick 1 alarm, 2 alarm, all the way up to 5 alarm, which was obviously really hot, and took a lot of water after eating that stuff. But I call this my 5-alarm case because this gentleman was a long-term employee, 16 years. He had developed a sleep disorder, and it was fairly recent. It was at or about the time that the pandemic set in. And his way of, with whatever limited medical attention he had available to him at the time, his way of dealing with it was, because he couldn't get up in the morning is what his problem was. He couldn't respond conscious enough to actually get out of bed and get himself showered and never really get to it. So he had 5 alarm clocks that he would set, and he would stagger them, and hopefully by the end of the 5th alarm clock, he was awake enough to, if he was going to be late, call in within the time frame that he was supposed to call in. And that didn't always work out for him. Some days he had 2 hours to call in from the start of the shift, and in many instances he didn't even wake up with 5 alarm clocks in that 2-hour period. So he had 2 strikes. He didn't show up for work at time, and he didn't call in on time. So anyhow, that was his presenting problem. He had not been able during the pandemic to get an appointment with a sleep specialist, and when he got appointments, he was often he ended up with COVID, so he had to reschedule. And at some point, the doctor's office closed for whatever reasons, but he could not get quick attention on this medically. And then ultimately, when he did, that doctor ordered a sleep exam, which, as some of you may know from your own family experience, requires the individual to go to a place, sleep there overnight. They get wired up with all these electronic devices or whatever, and then their sleep patterns are measured, and then the doctors are able to hopefully address the individual problems on an individual basis based on that sleep study. Well, as it turned out, by the time the case got scheduled, this sleep study he had been waiting 19 months for was scheduled for the very next night. So that had not yet been done, but it was imminent. And what the employer had been doing all this time was every 30 days they would lay another discipline on him because he was excessively late. And he would be late 3 or 4 out of the 5 days a week. And sometimes it was a half an hour, and sometimes it was 3 hours. So it clearly, from the employer's perspective, was affecting the work of everybody else who had to pick up his work when he was late. So I heard the case, obviously, both sides, and I was concerned about the timing of all this, because here the key element of whether or not this guy was going to be able to address his problem was like the very next day, and they wouldn't know the results probably for a couple of weeks. And he was a 16-year employee, which is a long amount of service in one job, and that deserves credit, in my judgment, when you come to a penalty in a system that is basically progressive rather than punitive. Somebody once told me when I started out in this field, somebody who's quite prominent and successful, said to me, arbitrators don't wake up in the morning intending to terminate somebody. And it was something that I took to heart. I don't wake up in the morning or walk into a hearing with the intention that I'm going to terminate somebody because the employer is looking for termination. So in this case, I came up with trying to balance the employer's concern for the employees who pick up the work on this guy's behalf when he's late, and the supervisors who have to deal with that rather than do whatever else they're supposed to be doing first thing in the morning. I put this gentleman on a long probation period. I took the termination penalty that the employer was seeking because it had used the every 30 days to have 5 or 6 disciplines for which the individual was fined as a penalty. But they used that to build the case for, okay, now it's time for termination. And I said, not so fast. I'm going to give this guy one chance with the help of the sleep study and his doctors to get a system in place, the meds or whatever it was going to take so he could get over this hurdle and get back to getting to work on time. And I gave him, I think it was 15 months if I'm remembering correctly, but I staggered it so that the terms of the probation, which limited how many times he could be late, and then when he had to document as opposed to not document his lateness. I staggered them so he had more available to him in the first 3 months of his probation, and then he had a few less available to him per pay period in the second 3 months, and I did that throughout the duration of the um, probation so that by the time he ended his probation, which if he successfully completed it, he would be treated like everybody else. This would be behind him. But by that time, his lateness conformed to whatever the employer's expectation was, and it no longer exceeded. The problem with these cases is they don't call the arbitrator back in 8 months or 10 months, whatever it is, and say, hey, you know that penalty that you put in there, it worked. The guy's doing great. So I never know whether these things work out or not, except maybe anecdotally. Well, that's what I did there because I felt that the equities for a 16-year employee who was struggling to deal with this late onset condition warranted it. If he had been a 3 or 4 year employee, he might not have gotten such a generous result out of it from me as the arbitrator. You have to remember in a discipline, you're determining somebody's fate. Do they have a job? Many jobs are the reason and the basis upon which people get health insurance. You have somebody before you who has a drug habit or who has an alcohol habit and they're in treatment and they fail their first rehab or something. So they're in and out of the work environment and they get more disciplines as a result of that. And they're struggling mightily to get over this thing. And then the employer wants to terminate them and take away the very health insurance that enables them to get the help they need in order to return to being a productive employee. So you have to understand fundamentally, as I said at the outset, the business model that you're in, the work environment that you're in, and make the distinction between conduct that is a flagrant disregard of the employer's rules and expectations, which have been clearly communicated, as opposed to the individual struggling with some anomalous situation that they or the family. So making a 180 turn away from disciplines is the other type of arbitrations that come up a lot, mostly in, or equally in labor relations arbitration, and those are contract interpretation cases. And those are cases that rely on the language in the contract, if there is language. And an example I'm going to use here of a case that I'm still struggling with. I haven't figured out quite what I'm going to do, but I'll tell you about the facts and what my thinking is. It has to do with seniority. Seniority is how long an individual has been in a particular job or a particular bargaining unit, as many of you probably know. And in the context of a contract, like the bargaining agreement, seniority can be the determining factor for a promotion. It can be one of several. It can be a factor of promotions, or it cannot actually be enunciated in the qualifications for a promotion, but it can be the practice that's always been considered, and that would be called the past practice. And there are rules for how and when an arbitrator can entertain testimony about something that has no language in the contract, but is a well-recognized practice between the parties. So I have a recent case that, as I said, I'm still kind of working through in my own head, where seniority is listed as one of 3 factors. Experience and skills being one, seniority being another one, and background education being the third. And the grievance arose because the employer gave the position that it was seeking to fill to a non-bargaining unit employee. It was actually a person from the outside, not even an employee in another bargaining unit. And the union grieved the matter along with the individual grievant and said that that's a total disregard of the language in the contract, which requires that seniority be a factor. And if you have somebody with no seniority, you're not considering seniority. So they took the grievance based on that argument, and the fact that the person who did get the job was an outsider, new hire. The testimony, which was by the head, mostly established through the testimony of the head of the department and the individual who actually made the selection. The testimony was that the head of the department was actually doing some succession planning when he filled this position. He was looking for somebody who had not only the skills and the experience and education to do the immediate job, but his intention was that this person would work for a year under the manager of that function. This was an accounting area in the department, and would then have the experience in the sense of the business model, but also have spent this year being mentored by that retiring manager and be able to move up into that management position when it became available. The manager's retirement date was already known. So that was how the manager who filled the position saw the opportunity and how he made the choice that he made. He was focusing on fit rather than on contractual language. So that's a difficult case. Missing from the equation in terms of there was no testimony for me as to whether or not this position was in any place or any way treated or considered to be a promotional position, or was it considered to be an open position where anybody and everybody could apply for it? There was no evidence about that. The supposition that the union's position was this was a promotional opportunity was based on the fact the union took the case, but also on the fact that the individual grievant on whose behalf the union took the case, she felt and testified to the fact that for her this would have been a promotional opportunity because it would have qualified her to then go on into some other jobs after a certain time. So that's a contract interpretation case. How do you interpret the language? How do you interpret the situation when there is no language and you have to look at what's happened in the past? And you always have to read the contract as a whole. That's one of the rules of the road. Seniority may be mentioned elsewhere in the contract, and you can draw on that if it's helpful in order to answer the question that you've been asking. But this case raises a different question, which I think is really important, and the last point I want to make to you, because I'm probably using more time than I'm supposed to, and that is how much should the arbitrator inquire of the parties during the presentation? And this is a very difficult question for most arbitrators. Some arbitrators will step in and take over the questioning in essence, or supplement the questioning in essence, whenever they feel they're lacking what they need, or it's not moving fast enough, or whatever it is that they feel they want to or need to, they'll step in and they'll ask a few questions, get what they need, and then the representatives will go back to doing their presentation. Other arbitrators will step in after they've heard a little bit. Sometimes the little bit is just opening statements, but usually it's after some testimony. They'll step in at that point because they've heard enough and they think they have a solution for this. And although they're hired to be an arbitrator in that context, they think they can work a settlement out. So they end up taking the representatives out to the hallway or whatever the equivalent is, and they spin out there, well, what about if you do this? Have you thought about doing that? And sometimes it works, sometimes it doesn't. But they step into the case rather than wait for it to conclude and then make a full written decision. Other arbitrators never step in. They'll leave with perhaps less than they would like to have, but they tread very lightly because they don't want to make one side's case or the other by virtue of their questions. And that also, this issue about the arbitrator stepping in also comes up often because in these labor relations cases, more so on the union side than the management side, you have lay people presenting the case. You don't have lawyer versus lawyer. You might have a lawyer to the employer, but you may have a lay person trained in arbitration and having the advocacy skills and all of that. But there is a difference in their fundamental understanding and it sometimes shows up in how the case is presented. And that may make for an uneven playing field, so to speak. So it might even create more of an impetus to jump in if the arbitrator is so inclined. For me, when I was doing arbitrations as an advocate, I intensely disliked when an arbitrator stepped in to a case, whether it was to help me or to help the other side. I intensely disliked it. I thought it was totally inappropriate, and it would send me off for a week in my mind about how bad that was. Now, as an arbitrator, at times I find it very difficult not to step in because I could cut through and get the nugget that I need or help the witness understand what the question is and get the answer that the witness has to offer much quicker than whatever is going on in front of me. And I have to really sit on myself not to jump in. I have to remind myself how much I didn't like it when I was an advocate. Once in a while, I don't abide by my own wisdom, so to speak, and I do jump in, usually to get the question clarified, but I do jump in. But my advice or my point for bringing this up is that you have to be prepared for the consequences if you're going to do that in your practice as an arbitrator, because you will possibly find yourself no longer selected in a certain environment, which is always the case. They might not select you for that. They might not select you because they think you're soft on this or you're too hard on that. But certainly, parties talk about arbitrators. They call each other if they get a list. If they don't have a closed panel, they call each other when they get a list from PERB or AAA or the NLRB or FCMS, whatever it is. And what do you know about this? What do you know about that arbitrator? And that's how the anecdotal stuff gets around, even if the parties have not had direct experience with somebody. If they get told, oh, this arbitrator always jumps in and takes over the case, that'll become their reputation. So you have to be really aware of that. As with anything else you decide, that, but interfering with the presentation of the case may cost you in the long run. So if you do find yourself doing that as an arbitrator, you have to do it with that rule. So I hope this is helpful. I thought a lot about how to put a lot of stuff into a short amount of time. I could probably go on for a longer time, but I hope this is helpful, and thank you for listening, and I wish you the very best of luck. Thank you.